All right, mic check, mic check, mic check. All right, I am so sorry for all of that to all of you guys out there. We are going to go ahead and start over, and we are going to cover everything from top to bottom. So, welcome to the Pro Stage Survival Show. I'm your host and your technical support person, which clearly failed there. So we've got everything on and going now, and I hope you guys all got a little bit of a laugh out of that. I am a little bit embarrassed on that stuff, but I hope you guys get a smile out of it. So tonight's live stream is titled Family Court 101: Who's Who and How the System Works. In the next hour, we're going to break down the basics of family court, how it all works. We're going to break it down into about 3 parts, especially for the fathers and men navigating the system on your own. The tone here is calm, experienced, and honest. I provide no bullshit. I will tell you what I feel about everything, and I won't hold anything back. So if you're looking for honesty, you're in the right place. I've been through this, and I'm here to help you survive and succeed. Before we dive in, shout out to everybody joining us live. Thank you very much. I appreciate you all for jumping out here and giving me your time to go through this. I will take questions live on the air here. So if you have a question, please don't hesitate to ask. I'm happy to provide that. That information to you. And we will, if we got to do a little bit of research and we run a little bit over that hour, I'm okay with that as well. I'm looking over here, just making sure that all of my bars are still moving here for mics and such. So, alrighty then. Okay, so segment 1 is who is family court and who are the players involved in it. I want you guys to all get a clear understanding of who's who and what you need to be paying attention to. So the judge is the boss of the courtroom. He or she hears the case and ultimately makes the final decisions on everything. On matters like custody, child support, or property division, they are the ones that are going to make the final decisions on stuff. They manage the proceedings, they rule on objections and the motions, and they issue orders, whether they're temporary or final. In a family court, the judge often encourages settlement. That's where you're going to find things like mediation, where they order mediation of the parties and stuff. That's what they are going to encourage you to do, is try to come to an agreement. They don't really want to make this decision on their own. They don't know your family as well as you do. They don't know your situations as well as you do. They don't know you or your ex as well as you guys do. So they would really like to keep out of it as much as possible, and they'd much rather just sign off on an agreement if it's reasonable and it doesn't seem like any party is getting kind of bullied or pushed into any sort of an agreement. You want to address the judge as your honor, and remember that they hold the power over all of your cases. So every aspect of your case, they hold the power to make all of those decisions. So make sure you respect them and you're polite to them at all times, even if you don't agree with their decisions. We're not going to win every single hearing that we go into. We're not going to win every single argument that we have against the other party. Sometimes the judge is going to go on their side. Sometimes they're going to jump on your side. That's okay. We want to take the small wins. We want to take those small victories and build off of them, okay? Again, the judge is making the final decision. They are the ones that are taking control of everything, and if there's a decision to be had and a decision to be made, they're the ones that are going to be making it, and they are the ones that are going to be making that decision in the end. So it doesn't generally come to a jury in this stuff. There are a small handful of states out there that do jury trials for family court, but they are far and few between. So it's just basically going to be you, the other party, the other party's attorney if they're there, and the other people that we'll go through here in just a couple minutes, like the court clerk and a court reporter and stuff of that nature. So welcome to all the live viewers. Thank you so much for joining here on YouTube and on TikTok. I appreciate each and every one of you. If you have a question, please drop it here in the comment section, and we will definitely get to your questions, and I will answer them the best I can, even if we've got to go through go and do a little bit of research here live and stuff like that. A magistrate is an associate judge. It's another name for an associate judge in some courts, especially the family courts. They have a heavy caseload, just like the judge does, and you might appear before a magistrate instead of the judge, or they may have a magistrate and an associate judge, so you may see an associate judge instead of a magistrate. It all depends on your jurisdiction and stuff like that. So definitely look into your own jurisdictions and stuff like that to know everything. Remember, I am just a paralegal. This is not legal advice. I have done this myself. I've represented myself, so I'm giving you information based on my own knowledge and my own experience in these cases. I am not giving you this because I'm an attorney by any means. There is no attorney-client privilege here. I am just providing this strictly for educational purposes to the best of my ability. Okay. So continuing on with the magistrates, they are judicial officers. They do often handle preliminary matters, temporary hearings, or specific issues that help judges manage the load. So in my home state, the magistrates handle most, if not all, of the initial child support proceedings. Unless those child support things are appealed to the local level, then it jumps up to the judge. So let's see here. They usually have to meet the same qualifications as a judge, and they can issue orders as well. In many cases, the process with a magistrate is almost the same as with a judge. You present the case, they make recommendations or rulings. They also like agreements, just like the judges do, so they may order some mediation, or they may be very, very on board with the parties coming to a agreement between themselves. They don't want to make these decisions either. They don't know you, just like the judge doesn't know you. Often, if you prefer a judge to handle your case, you have a limited time to object to the magistrate being assigned. If the magistrate makes a ruling you disagree with, you may be able to request a hearing before a judge to review it. Think of the magistrates as the judge's right-hand helpers who keep the cases moving, so that the judges don't have an exponentially large caseload. They can handle the things that are more critical and more complex. The judges, that is, handle things that are more critical and more complex. Court clerk. This is the official record keeper, okay? They're the person that documents everything. They're considered case managers, and they do everything for documentation and keeping track of everything that's filed and keeping everything in order. If the judge is looking for a particular document, they can't find it in the docket, they're going to look at the court clerk and they're going to say, hey, where is this? Where do I find this? And the court clerk is going to help them through that. They're usually at a desk there in the window, desk at the courtroom, and they handle the filing of the documents, the scheduling of hearings, and the overall paperwork of the case. They also may swear in witnesses or mark exhibits during trial. They do most of the exhibit markings. The judge will usually swear you in, or one of the court officers, like the bailiff, which we'll get to them here in a second. Not usually the court clerk will be the one swearing you in, but sometimes they do. They can offer basic procedural answers to questions that you have. Do I need 2 copies of this? Is this the form that I need to fill out? Et cetera, et cetera. They can offer no legal advice. They cannot tell you what to put on the form. They can't tell you what words to use on the form. They can't give you any of that stuff. They are not legal advisors by any means, and they often do not step outside of their boundaries. They are very, very strict to this. So if you ask them a question, don't be afraid to ask them a question, but be prepared for a response like, I can't give that answer to you. You would have to go ask an attorney for that. In some places, especially older terms, you might hear prothonotary, which is essentially a clerk with a fancy name. They're responsible for keeping track of filings and exhibits and sometimes administering oaths. Again, the bailiffs generally do the oath administering, and the judges. Get to know your clerks, be polite and organized with them. It can go a long way since they are the gatekeepers of everything. So if you're nice to them, they'll generally in turn be respectful to you, and they'll do their best to keep the case moving and stuff. The bailiff is the court security, and they are the order keeper. So they are the ones that are going to take you into custody if you're held in contempt in order to be hauled off to jail or something like that. They are also often the ones that are law enforcement officers, so they will issue an oath and keep everything in line. They'll often announce the judge's entrance by stating, "All rise." This is important. You are absolutely required to rise at that stuff. If you don't, you're going to kill respect from the judge and basically every person working in the courtroom at that time. If you have a physical disability, that's a different aspect, so they're not going to expect you to rise if you're physically disabled and such. They call each case when it's time to start, so they're going to call the case of Smith versus Smith or Jones versus Jones, and that's going to officially put the docket on the record, and the judge is going to acknowledge that, and they will probably repeat that and start to go forward. Bailiff also escorts the parties or the witnesses to the stands, and if you have documents or evidence to give to the court, the bailiff might be the one to take it to the judge. They don't allow you to approach the bench like you might see in like television shows and stuff like that. The bailiff, if you have a document or something like that, hey, I have Exhibit A that I'd like the court to have, the bailiff's going to come and take that to you and bring it up to the judge. Essentially, they're there to ensure that everyone follows the rules. Right? If the judge says that you're out of line, the bailiff is going to make sure that you get back into line. They don't allow things to get out of hand. They are very, very strict. No matter how heated things feel, never argue with the bailiff. And the court staff, they do have the ability to arrest you. If the judge says take them into custody, they will take you into custody. All right, moving along. Mediators. Outside the courtroom, many family courts use mediators to help parties settle their cases. Okay, before the judge is seeing them. Again, this is highly encouraged by all of the family courts. Pretty much anything civil is encouraged to be settled outside of the courts to help try to save money and time of the court. A mediator is supposed to be a neutral third party, and they're often a trained professional, maybe an attorney or maybe a mental health counselor or a counselor of some sort, and they facilitate negotiation between you and the other parent. Mediation sessions are usually confidential and informal. The mediator doesn't take sides or force a decision, but helps both parties communicate and find common ground. So maybe you can't figure out exactly what that custody agreement's going to be. Maybe you don't agree on visitation. Maybe you think that you're entitled to more visitation. Maybe mom wants to have more time. Maybe you don't agree with primary placement of the kids. You think mom thinks they should be with her. You think they should be with you most of the time, etc., etc. The mediator is going to try to find the common grounds in those issues. Maybe you guys agree on things like who gets what car. Okay, mom generally drives this car all the time, so mom is going to take this car and you're going to take that car. If you guys agree on that, that's common ground, but there's still other issues that aren't agreed upon. So you can still go through in a mediation session and hammer these little things out, and you can get these little things to be decided before you actually make it to the judge, so you're not going in there and arguing hours and hours and hours of things that you do agree on, and you can focus on the things that you don't agree on. Again, they are very confidential, so anything that happens in mediation stays in mediation unless there are laws that are being broken or people are at risk and it's a mandated reporter kind of thing. Everything in there, these are called settlement talks, and they are strictly confidential. Even if you're not in with a mediator, if you're having settlement talks and you're talking about potential agreements, they are strictly prohibited from coming into court unless there is legal things that make it to where they are admissible in court, like threats and things that are by law reportable. In a lot of places, mediation is required or at least strongly encouraged before you can proceed to trial. If you already have an order in place, mediation is usually required before you go back in to modify anything. So you may have to go in and go to a mediator if you file a modification to your child support or you file a modification to your child custody agreement. You're probably going to have to go to mediation first. If you reach an agreement in mediation, the mediator is going to draft that stuff up, and they're going to submit a draft to both parties to make sure you guys agree. Once they have it all in writing, they're going to submit that mediation agreement to the judge, and it's pretty much going to become solidified in stone. It's called a stipulation at that point, and that mediated agreement is going to generally be signed off on the judge unless he or she sees some glaring things in it that are illegal, it's not something that they can agree on, or they're fundamentally unfair. Things that often can't be agreed upon are like child support. Child support goes by very specific guidelines, and if you're really, really far off those guidelines, then the judge isn't going to just sign off on that stuff. So if you agree to a zero child support order, but mom has the kids 90% of the time, and mom just says that, okay, I'm not going to take any money from you because blah, 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 the judge is probably not going to sign off on that because they have a duty to make sure that they're staying close to the guidelines in child support stuff. So unless it seems very, very fundamentally unfair, the judge is generally going to go with a mediated agreement. If you can't agree, you at least tried, and you'll proceed with your court case. You'll end up going to trial. You'll end up in your pretrial conferences, and then you'll eventually end up in trial. Think of mediators as a peacemaker. They're not there to get into the courtroom drama. They're not there to get into the back and forth. They are going to just sit there and hang out with you guys and try to find that common ground and see what they can find as issues that you can agree on. If they can't, if there is no agreement at all, then that's what they file. They just file a piece of paper with the court that says that there's no agreement, but it is proof that the parties attempted to mediate. So when you're in a mediation, make sure that you're in there and you're still being very polite to the mediator. You're not trying to create controversy. You're not getting all worked up. You're not getting, you can get frustrated and you can have those visible emotions and stuff like that. Don't take them out on the mediator. The mediator is just there to try to keep things moving along for your case. They probably don't want to be there as much as you don't want to be there, but they do want to try to help the two parties come to an agreement. So it may feel like they are not neutral. They may feel like they're on the other side. That's because they have a lot of experience in doing this stuff, and they generally know how the courts are going to respond to these types of things. So if they seem like they're pushing you in a particular direction that you don't want to go, it doesn't mean that you have to go in that direction, but they are trying to give you some additional information, okay? A mediator should never be giving you legal advice. Even if they are a licensed attorney, they are not in a position to be able to give you legal advice in your case. So make sure that you're staying away from and clear of that stuff as well. Court reporter. If you ever notice that there's somebody sitting in the judge and they seem to be typing away on their keyboard or they don't seem to be paying attention, believe me, they are. They're listening to everything and they're recording everything that comes out. They're quietly clocking away on a little weird machine, and that is because they are typing everything out that's being said in court. Most of the stuff is handled by audio recording, so they may have some headphones on and they may just be listening to everything to make sure that everything is audible enough for them to be able to hear, because eventually down the road it might be transcribed and it might have to be put down on paper. So they're going to be listening to the entire proceeding, maybe through a set of headphones or something, so they know that the hearing is recorded appropriately and they're getting all that information. So make sure you're speaking loud enough and clear enough that it can be picked up by audio recording. That's the court reporter that's sitting in there. That's what their job is. Their job is to transcribe everything that is said, or at least make sure that it's being recorded appropriately. In family court, not every minor hearing will have a court reporter present. Some courts use that electronic recording and they just assume that it works, and so they don't have anybody really double checking it in any sense. But trials and important hearings often will have that court reporter in there to make sure that a transcript is produced. The transcript they produce is going to be critical because it could become evidence for like an appeals court or something to that statement, or if you come in for another hearing later down the road, maybe your hearing is split up into a couple of things, you can ask the court to refer back to a transcript. You can ask that court reporter to read back what was said, what question was asked, how that answer was answered, and you could use that as impeachment evidence, meaning that, well, you just testified to this is what you said, now I asked you this question and this is what you said. So it can be used in that aspect as well. The transcript they produce, for you as a pro se litigant, this means they speak clearly, for you as a pro se litigant, this means speak clearly and at a moderate pace. Don't speak really, really fast like I am right now. Sorry if I am speaking too fast. Please let me know in chat if I am to just slow down a little bit. I'm happy to do this, but I want to cover all of this information in the time that we have as well. So that's why I speak fast, but in court, you want to make sure you're speaking at a nice, moderate pace and clearly and nice and loud, so that everything can be picked up on that recording if it's being recorded, and so the court reporter hears you. Answer questions with words like yes or no instead of nodding. So everything is understood and so everything is clear. If you mumble or talk over somebody, it may show up on a transcript as inaudible because they couldn't figure out what was being said, or you were you spoke over the other person and the other person was speaking loud as well, so you can't really, the court reporter, the inaudible just means that the court reporter couldn't understand what was being said. So it doesn't help you in your case at all. Those things are inadmissible and they just get thrown away. They get tossed to the wayside. The reporter is essentially creating an official memory of the case. Okay, they're putting a memorial, the case in a memorial so that it can be looked back on at a later date. Guardian ad litem. These are a person that are assigned for the children. They're assigned to not decide, but they are there to protect the children's rights and talk to the children and help the court decide what's in the best interest of the children. That's what they represent, is the best interest of the children. In many cases, in many states, guardian ad litems are attorneys. So your child is essentially getting an attorney, but they don't actually call themselves an attorney. So they can't give legal advice. They can't tell you how to proceed in a case. They are just there looking out for the best interests of the children, and they apply what they learn in their conversations with the kids to the best interest standards in the statutes of your case. Not every case gets a GAL, as they're oftentimes referred to, but if there's allegations of abuse, there's super high conflict, or the judge wants an independent investigation into what's best for the kids, a GAL may be brought in. A GAL can be an attorney, a mental health professional, or a trained volunteer, depending on your state. They investigate the family situation. They might interview both parents, talk to the children, and contact teachers or doctors, do home visits, etc. Ultimately, the GAL will write a report to the court with recommendation. It's not the final word. The judge makes that final decision. It's evidence the judge considers. Okay, you will often have a chance to read the report, and in many cases, you will have a time to object to the report and anything that you find as that you don't agree with in there. The rules vary from state to state, so again, make sure you are checking your state rules for all of this stuff. I am a paralegal. More importantly, I'm a freelance paralegal. I'm giving you all of this information from my personal experiences and for educational purposes only. So if you feel unnerving to have someone essentially evaluating your parenting, but you try to cooperate with the guardian ad litem as best as you can. Be honest. Don't try to hold back punches. If you have done wrong in your marriage and things got out of hand and whatnot, then you need to own that, and you need to accept that, and you need to understand that stuff is going to come out, and you need to own it with a presentation of what am I doing? How am I going to fix this going forward? These were issues between Mom and I because the marriage was falling apart. I was under, X amount of stress. I've gotten counseling now. I'm working through this stuff. I'm in a better place because the marriage has ended, and I've worked through those problems, and I'm working to become a better person. They're there to advocate the child, essentially not trap you. It can feel like they're trying to trap you and that they're trying to take your kids away and stuff like that. But again, if you've got situations from your past through the marriage that aren't pleasant, those things are going to come up. Be honest with them, be open with them, show that you've reflected on them, and show them that you're trying to do something different. If you drank a lot throughout your marriage and you are being accused of being an alcoholic, show what you're doing to fix that stuff. Show that you're not still drinking, a half gallon of tequila every day. Case managers, moving on here. Case managers are, let's see, how can I put this? For some courts, they have case managers or family case managers who help self-represented parties keep their cases on track. So they're there to help keep things moving and make sure that things don't go stagnant. Okay, a case manager isn't a judge or a lawyer. Think of them as a resource person or an administrator. They might coordinate case manager conferences where the judge checks on the status of the case. Okay, they just checking in to find out, have you guys mediated? If you have, has mediation been completed? Was it successful? Was it not successful? How long is a trial going to take for you guys? So that takes a time estimate. How many witnesses are you going to call, stuff like that. They're going to put all of those things together and help the judge establish what the status of the case is and what the trial is going to look like, so that they can schedule enough time for your hearing, try to get you in there for your hearings when in a reasonable amount of time and stuff. Make sure you file. They're going to help make sure that you file the right forms. Again, they're not going to tell you what to put on those forms, but they're going to make sure the forms are filed. So if you're in a dissolution or marriage, they're going to make sure that the petition for dissolution is there. If you're there for a parentage thing, they're going to make sure that the petition for parentage is there. They're going to make sure that financial affidavits are there. They're going to make sure that if you're in a parentage situation or you can test a child being yours, that you are going to submit to a DNA test, and that the DNA test results are there, and that everything is essentially there and ripe for trial. Again, they cannot give legal advice or tell you what to say. They can't fill out your forms. They can't give you a strategy. Nothing you tell them is confidential or protected by attorney-client privileges, but they can explain the procedures, provide informational forms, and a good case manager is like a guide, but they won't hold your hand. They will point you in the right direction so that you don't get lost in the procedural stuff, okay? If your court offers a self-help center or a case management office, use it. It can be very, very beneficial to help keep things on track. They can tell you where to find things. Think of them kind of like me and what I'm doing here, where they're not providing any sort of legal advice. They have experience from working in the system, navigating the system. Maybe they've done this themselves, so they have the tools and the resources, or at least where to go to get the things that you need. If they just definitely use it. Okay, just remember that they're there to assist with the process, not to advocate for you. So they're gonna be very, very neutral, and they're not gonna jump on your side. Okay. Opposing counsel, okay, this is probably going to be your nemesis. They are absolutely going to feel like the enemy, and they are absolutely going to sound like they are 100% against you, and that they are trying to prevent you from getting your kids, or they're there to prevent you from getting what you want in it. They are absolutely there to do that. They are there to represent the best interests of their client, which is your ex, and they are going to be in there. They work for your ex, so they're going to be doing whatever your ex tells them to do. If your ex tells them, I want 100% custody, and even if they tried to talk your ex out of going for 100% custody, if that's what your ex says that they want, that's what they have to go through, okay? Opposing counsel simply means a lawyer representing your ex or the other parent. Their role is to advocate for their client's interest, which often means pushing for the results that you might not like. Just kind of as I was just saying, they'll file papers, negotiate, and argue in court on behalf of the other party. It's easy to see them as the enemy, but think of them as just doing their job. Their job is to represent their client zealously. They are not your enemy in a personal sense, and importantly, they are not the boss of you either. You do not have to do everything the opposing lawyer says. You only follow court orders, not opposing counsel's requests. So just because they ask you to do something or tell you, hey, let's get this stuff done, the court's going to like it, doesn't mean you have to do it. But that being said, be professional and civil with them. Many attorneys will treat a respectful pro se opponent with respect in return. They're used to dealing with other lawyers daily. Don't be surprised if they communicate in legal jargon or seem a bit blunt or even intimidating. So sometimes their emails or tone can feel harsh. Stay calm, pick your battles, and remember that you have to stand up for yourself. And we'll talk more about that when handling opposing counsel who might be aggressive or trying to overwhelm you. Some of them can be very, very overwhelming. They can be very, very aggressive, and it can really take a toll on a pro se litigant. So be prepared for that. Be ready to take control of that stuff, okay? Those are the main players. Of course, there may be others as well. Caseworkers if Child Protective Services are involved. Interpreters if someone has a language barrier. Support people you bring along, though they can't usually speak for you. But the ones that we listed are almost certain to appear in every single family court case. Take a breath. That's a lot of information, isn't it? Okay? The key is that each person has a specific role. They're not all against you. Understanding who does what will help you interact appropriately. Okay, if you walked into a courtroom and didn't know who some of these people were, you're not alone. Everybody goes through this. We learn about these people as we go along in the process. Sometimes a court officer or judge will introduce people and let you know who they are before an official hearing gets underway. This is kind of like a one-time thing. They'll do it at the very beginning of a case, just so you know who they are, especially for pro se people. They like to keep everybody out there and make sure that everybody knows what's going on. All right. So let's move on to section 2 here, how the system flows and step by step from the filing to the final orders. In this segment, we'll walk through a typical family court case timeline. Every case is a bit different. Every jurisdiction is a little bit different. Your county rules are different. The way things move in your county or your state are going to be dictated by your state rules. So make sure you're checking them. Again, I'm just a freelance paralegal. I am not an expert. I'm not a lawyer. I'm just giving you information from the things that I've experienced and trying to help you all out. I'll explain step by step, or I'll explain each step and what happens and what you should be doing as a pro se litigant at that stage. By the end, you should see a big picture of how the case moves through the court. So initially, every case starts with a petition. Okay, you petition the court for action. You tell the court, hey, I want a divorce, or hey, I want to establish my parental rights, and I need to establish my parentage in this situation. So you file a petition. These are most generally always available in generic forms that you can find on your state court websites, judicial websites, county court websites, and stuff like that. You can download them and then you can fill them out using your own words. Again, some of the people all of the people up above, unless they are attorney representing you, can provide no legal advice, and they can't tell you what to put on those forms. They all have to be in your words. If you were to come to me privately and say, hey, Don, help me out with this form and stuff like that, I can only help you understand what each section is trying to tell you. I can't tell you what to put in each one of those sections. So if we're looking at the name and the captioning of the case, I can only tell you like who the plaintiff is and who the defendant is based on the information that you've given me or handed me, official documents from the court showing that stuff, or who's filing what. If you're filing a response to a petition, then you're generally the defendant. If you are filing the petition yourself, then you are generally the plaintiff. All right. As I said, every family court case starts with filing a petition or a complaint. This is if you are the one bringing the case, like filing for a divorce or establishing custody or visitation. In the petition, you state what you're asking for. For example, custody arrangements, child support, or a divorce decree. The person who files is usually called the petitioner, and the other party is called the respondent or the defendant. Along with the petition, a summons is issued. Basically, it's a notice telling the other party that you filed in court and that you guys are going to court to find out what what's going to happen from here. That summons has to be officially served on the other party, either by a law enforcement officer or an official person designated by the court that has authorization to file those documents. You cannot serve documents on the other party. Just because you read a rule somewhere that says anybody over the age of 18, if you read further into that rule or get into case law and stuff like that, usually you will find that you are not one of those over 18 people that can put that stuff in there. So you need to make sure that those things are filed correctly and then served correctly. They have to be served by a licensed service processor or a law enforcement officer. Nobody else can file that stuff, especially for the initial proceedings, okay? If you're the petitioner, you're going to prepare the necessary forms, which, again, you can get from the court self-help center or the court's website. Double check you're using the right forms and that they're filled out correctly. When you file, there's usually a filing fee, which can sometimes be waived if you can't afford it. Ask for a fee to be waived. The court will stamp your documents and assign you a case number, and that case number is going to be crucial. That defines your that's how they identify your case going forward. They're going to give you a copy of those stamped documents for your records. If they don't hand you a copy automatically, ask for the stamped documents themselves. After filing those papers, we're going to get specific into that service of process again. After filing, those papers must be served to the respondent or the defendant. This means officially delivered, usually by by a sheriff's deputy or a private process server, sometimes by certified mail. Not all the time can it be served by certified mail. Read your local rules and regulations about that stuff in certified mail. Usually, initial process needs to be filed by or served by one of those official process servers or a deputy sheriff or law enforcement officer. Okay. If you're unable to get the documents served, then there are rules about when you're having difficulty getting process served, which might be getting it published in a local newspaper or something of that nature. But you need to seek leave from the court to do that, or you need to ask permission from the court to be able to do that. And that is only if they're really hard to find and usually takes the sheriff coming back to you and saying, I couldn't serve these papers, I couldn't find them. Or that private process server coming back and saying, I couldn't find this person, I couldn't serve this stuff. You'll get documentation of that stuff, and then if you're looking to put that stuff out into a publication, into the newspaper or something, then you file this stuff with the court and ask the court for permission to do that. Proper service is crucial, okay? If it doesn't happen, then your case is going to get thrown out of court, and they're not going to, it's never going to proceed any further, and every court usually has a, or at least under my understanding, every court has a timeline for when service of process needs to happen, and if it doesn't happen by that point, then they just automatically throw it off the docket, and you end up having to refile down the road. They need proof of service, so you're going to get a form handed back to you by that process server, whoever it is, law enforcement officer or private process server. They're going to give you a form back that's going to have the process server's signature on it. It's going to have the time and date that it was served, and it's going to have a signature from the other party stating that they've received those documents. That's your official notice to give back to the court to say they have been served. As a pro se litigant, you typically cannot deliver your papers yourself. Once served, a proof of service is filed with the court, and the document step is to document that step is done, and no service, no case progress. So once this stuff is served onto the court as service of process is completed, then your stuff moves to the next phase, which is going to be like a case managers conference, status conference, your initial hearings, stuff like that is going to start to kick off, and you're going to get some paperwork from the court in the mail. So pay attention to your mailbox from there. If you filed electronically and you've allowed the court to accept electronic filing and that you will accept service by e-filing, then they'll usually send you an email and stuff like that. So make sure however you file is going to be the way that you pay attention for things. So if you file electronically, generally you've acknowledged and accepted that you will receive electronically, so keep an eye on your email. If they sent the email and you say you didn't get it, they're probably just going to blow that off essentially and say, well, you agreed to service by email and we sent it out. This is an official process. We didn't get any bounce back, so that means that you got it. If you are the respondent, you don't have to worry about filing the initial petition, but you will be on the receiving end of the service. So if your ex is the one that filed for divorce, they are going to serve all that paperwork back on the court. That signature that you gave to the law enforcement officer saying you were served, that is going to be sent back over to them. And you don't have to worry about filing the initial stuff, but you will be keeping an eye out in the mail from there for any additional court documents. Mediation, stuff like that is going to come forward. Guardian ad litems are not generally established right from the gate, so a petition for divorce is not necessarily going to establish a guardian ad litem. There's going to be a hearing on that to have that ordered by the court, and then that process would go forward. Okay. Excuse me. All right, so the response, answering the petition. After the petition is served, the clock starts for the respondent to file a response, often called an answer. In many jurisdictions, it's around 20 days, 20 to 30 days. Check your local rules to find out how long you have to respond to it. You can call your case manager and ask those kinds of questions. They will explain that process to you, but again, they won't tell you what your response can be, how or anything like that. They can only give you the directions of what forms you need to fill out in order to give that response, and how long you have to do that. The response is your chance to tell the court what you agree with and what you disagree with. I agree that our marriage is irreconcilable and we're never going to get back together, and that we're living separately, or that we're living together in the same home but we are living separate lives and stuff like that. It also gives you the chance to offer your own requests. Sometimes that's called a counterclaim, but you're basically looking at the court and you're saying, I want the house, I want the kids, I want child support, I want this car, I want that bill, I don't want this, I don't want that. That's for you to be able to put into your response. If the petition asks for sole custody to mom and you're the dad responding, you might agree on some points but counter that you want joint custody or primary custody. It's very important that you file an answer on time. If you don't, then the petitioner can file for a default judgment, meaning that the court proceeds without your input and might grant whatever the petitioner was asking for. So, and the same goes for you. If you're the petitioner, if they don't respond in 20 days, then you can ask for that motion for default judgment, and you might get everything that you've asked for as well. If you're the only one that filed in the case, the respondent's answer will come in. If you're the one that filed in it, the respondent's answer will come in, and you'll know what issues they agreed to and which ones are contested. Once the initial pleadings are in, the case is at issue, and the court can start moving it forward. Often shortly after the answer is filed, the court will schedule an initial hearing or a case manager conference. This is where they're going to establish what the parties want, if there's anything that the parties can do to agree on things, stuff like that. This might be a short meeting where the judge or a magistrate looks over the case, ensures that both parties are aware of their obligations, like parenting classes. Most jurisdictions require a parenting class for you to go through if there's children involved, or mediation requirements. They'll set some deadlines for like discovery and how you guys are going to relay information to each other for like evidence and stuff, and witness list, et cetera, et cetera. Think of this as basically a check-in and a planning session for the case. Not every jurisdiction has a formal conference, but many do, because again, the court is trying to make things as efficient as possible, so they want to see if the parties have anything that they can agree on. I'm going to take the Subaru, she's going to take the Prius, stuff like that, okay? They want to try to make this stuff as efficient as possible so that they can try to get everything through. These courts are absolutely packed to the brim with cases, so they need to try to do everything they can to move this stuff forward. Family court cases can take months or even longer to finish. I can tell you that mine took over 18 months to come to conclusion for the initial thing, and then when I filed for a modification of my child custody stuff, it took almost 2 years for that stuff to come through. So it can take a while for things to come through because, again, the courts are packed with these cases and their dockets are jammed. So the schedule is often booked far in advance, and you have to wait for your name to come up on that docket. That's where these temporary orders are going to come in. We're going to talk about temporary orders in another session, but either party can request a temporary hearing early on to establish short-term arrangements, for example, temporary custody and visitation schedules, temporary child support, temporary spousal support, or who stays in the house even. Temporary order hearings are usually quick. Each side might get a short time to present some evidence, perhaps affidavits or very limited testimony on immediate issues. Then the judge or the magistrate issues an order that will govern while the case is pending. These orders expire when the final order is entered, but they can last for the whole duration of the case. An instance of temporary custody order might say that the parents will share time week on, week off until the final court date, or a temporary support order might require one party to pay a certain amount monthly, and temporary orders don't decide the case for good, but they can feel like a big deal because they set the status quo. Follow them carefully. Violating a temporary order is just like violating a final order. You can still be held in contempt. It will damage your credibility when you get to a final hearing, and you don't want any of that stuff, okay? Also under this category are immediate emergency orders. In some cases, if something is urgent, say a risk of abuse or abduction, then a party can sometimes get an emergency order ex parte, which means that the other party isn't present. Usually neither party is present in there, and the judge issues it based on affidavits and the request from the other party. So these are very, very specific. There are very, very specific rules to a judge issuing a ex parte order, and they do not take issuing these orders lightly. So you need to fall within those things. These can sometimes feel very, very unfair if you are on the receiving end of them. So But if you are on the receiving end of them, take a deep breath. Go vent to somebody else. Don't vent to the court and stuff like that. You need to really, really take your time and chill out with this stuff, okay? It's hard to accept an ex parte order because of the allegations that come against you. They usually seem to be very, very off-putting, and I often hear a lot of dads say that the other side is lying or false allegations, stuff like that. I understand all of that stuff. I get that stuff, but you need to understand that you're going to have to overcome those allegations, especially if the court has issued that that emergency order, that temporary order. All right. Mediation and settlement efforts. As we were talking about earlier, the courts generally encourage the parties to settle their differences without a full trial. They want that to happen so they can kick you off their docket and they don't have to listen to everything in a full-blown hearing, and then the judge having to make those decisions for your family. After the initial filings and any temporary orders, many family courts require mediation. Or some other form of alternative dispute resolution before going any further. In mediation, as we discussed under the who's who, you and the other party sit down with a mediator to see if you can agree on some, not necessarily all, but some of the issues, hopefully, or maybe all of the issues. Generally not likely that you're going to agree on everything unless you kind of really sat down beforehand and really came to terms with this divorce or these proceedings, and you guys have really already established an agreement for the most part, and you're just going to the mediator to formalize all of that stuff, okay? Why does this happen? It's because if two of you can reach an agreement, you save yourselves and the court a lot of time, a lot of stress, and a lot of money. Judges often say the best agreement is the one you create yourselves, and it's true. You'll likely be more satisfied with a mutual agreement than a court-imposed one, okay? So what the court is trying to get across in this aspect is if the court orders, if it comes down to the court having to make the decisions for you, chances are you're going to be back in court to modify that order and to try to change things. If you come to an agreement between you and the other party, then it lessens the likelihood that you're going to be back in court to change that agreement, unless one or both of the parties have come to an impasse on one of the issues, and they just what's in the mediation agreement or what's in your final agreement just isn't working. But generally, those agreements often work, and they work well throughout. So during this mediation or settlement efforts, you might have one or multiple mediation sessions. Come prepared, know what you want, but also know what you could live with, okay? So what I often think about in this situation is be ready to say, I want 100% custody, but I'm willing to settle for 50-50, okay? I can live with both parents having equal time with the kids. I really want my kids to be with me all the time, right? I really, really wanted that from the beginning when they were born, and that's kind of why I was married to the person, or that's why we decided to have kids together, because we expected to be there 100% of the time. So effectively, I want 100% custody of my kids. But because we are split, to be fair, I want 50-50. Okay, and I can live with 50-50. Maybe you've decided to that you're going to be living in a completely different area because maybe work offered you during this process, your job offered you a better opportunity. You're going to be making more money that will be able to provide better for your kids in their future. So you've decided to move 3 hours away, but you really, really believe that the kids are better off by staying where they are because they have a great school, or they have great relationships with their teachers, or there's something solid there that keeps things for your kids, or you just want to keep them in the home that they were raised in for most of their lives, and that's where mom is going to stay, and that's the agreement that you've come up with there. You want to hash this stuff out in your mind and come up with what you're willing to live with. If you're going to be living a long ways away, and that's what you feel is best for you and your family, or that family being you and your kids, then you have to make some sacrifices on the other side as well. So you need to figure out what you're willing to live with and making those sacrifices. Be polite and listen, and try not to let emotions derail the talks. When emotions come into it, it becomes very, very difficult to come to any sort of an agreement. So really, really keep yourself and your emotions in check, okay? As a father in particular, it might feel like you're fighting an uphill battle. Most fathers feel this way, and they feel like everything is stacked against them. Show a willingness to cooperate. It can only help your image. It helps your credibility in court as well in front of the judge to show that you are showing a good faith effort, okay? If you reach a full agreement, the lawyers, or you, if you're both pro se, can draft a consent order to settlement agreement to present to the judge. This is just a formal document that says this is what our agreement is. Can you sign off on it, Your Honor? Often a final hearing becomes just a formality to approve the agreement. In some jurisdictions, they'll just sign off on it without a hearing in some cases, especially if you're both represented by attorneys and your attorneys both came to mediation, were present in mediation. They will often sign off on it without even having to have that final hearing, and you'll receive everything either through your email if you've e-filed, or through the U.S. mail if you filed that way. So if mediation doesn't result in a full deal, don't be discouraged by this. Sometimes you might settle some issues and narrow down what's left for trial, which means you don't spend 3 or 4 days in a trial or all day in a trial. You might agree on a holiday schedule, but not who gets primary custody during school. Whatever you can agree on, do it, okay? Don't derail your entire mediation because you can't come to an agreement on all the terms. If there are some things that you can put into an agreement, do it. Again, it's going to help your credibility in court. It's going to help the judge see that you're putting in good faith efforts and you're really trying on this stuff. It does simplify the trial, and if you truly can't agree on anything substantial, at least you'll leave the mediation knowing exactly where you guys stand. All right. Moving on here to discovery. We're going to run a little over this hour here, okay? Running parallel to mediation, there's a discovery phase. We're going to go into this in detail in another session of what discovery is, evidence and stuff like that, but discovery is just a fancy term for exchanging information and evidence with the other side. You're both entitled to whatever evidence the other side is going to present. You're both entitled to see that stuff before trial so you can provide and prepare a proper defense, okay? It's how both parties prepare for trial by making sure there's no surprises. In family court, discovery can include interrogatories, which are written questions to each other, and requests for documents like bank statements, school records, medical records for the child and stuff like that. Requests for admissions ask the other side to admit to something. Your ex might say admit to the fact that you have a domestic assault on your record, which is going to be super, super damaging to you in trial. But again, you can't lie about it. You don't want to hold it back. You just need to own it. You need to accept it, and you need to be ready to tell the court what you're doing to fix that things and move forward so that it doesn't happen again. There might be depositions taken, which is out-of-court testimony. It's still under oath. It's usually used in more complex cases, and there's usually a court reporter there to document the entire deposition. Again, so there's transcripts and stuff like that. So when it comes to testimony in court, they have something to hold you accountable for, too. The goal for discovery is to get everything out on the table, to get all the facts out on the table, and again, so everybody has a chance to see things, so there's no surprises in trial. As a pro se litigant, especially if you're up against another attorney, discovery can feel very, very intimidating. It's very legal in nature, but it's important. For example, if you're seeking custody, you might gather school report cards, a log of your involvement in the school activities, or text messages showing communication between you and the other parent. The other side might request your pay stubs or emails. You must comply with the discovery request in a timely manner, and they must comply with you. If the other side's lawyer sends interrogatories, you'll need to send an answer to them under oath by the deadline. You can send your own interrogatories to them. Be truthful and thorough. Lying or hiding things in discovery can seriously backfire on your credibility in court. Credibility is probably one of the biggest things in court, for the court accepting your words and stuff like that. You are under oath in interrogatories, even though they're written statements. You can object to the questions that people ask, but you need to file those objections in your answer. So I object to this question and what your foundation for the objection is, etc. When it comes time for court or in a status conference or pretrial conference, the judge will generally rule on those objections in the interrogatories because the opposing counsel is going to raise that issue. Once the judge rules on that objection, you need to follow whatever the judge does. If the judge overrules your objection and says you need to answer it, then give them the answer. If they say, if they agree with you and they sustain your objection, then sustaining an objection means that they agree with your objection and they are going to, and you don't have to answer that stuff. Okay. During discovery, you might also get some expert evaluation. Sometimes, especially in contested custody cases, the court might order one party, or you might get a custody evaluation by a professional like a psychologist or a social worker, and they'll investigate and make recommendations to the court. A guardian ad litem, as we discussed earlier, can be seen as part of the discovery process as well, since they compile evidence for the court. There might also be psychological evaluations, home studies, or drug tests, depending on the allegations in the case. So be ready for everything that might be thrown at you. You do have the ability to object to some stuff. If that objection is overruled, you're going to have to supply that stuff. So if you don't believe that you should be subjected to a drug test, but the judge says you're going to take a drug test, then you need to deal with it and you need to go and take that drug test. Don't get mad. Don't argue with the judge. Just say, yes, Your Honor, I'll submit to the drug test. Where do I go to do it? They'll give you that information. You go get it done. You submit it. It's done. If it comes back negative, great. You've proved your point. If it comes down positive, you've got a hurdle to overcome, okay? The stage needs to be very organized. You want to make sure that you're keeping track of everything in the discovery process, everything that you've asked for, everything that's been filed on you or given to you as part of the process. Put it in a binder, tab it, put tabs in it so you can flip to it easily, et cetera, et cetera. Like I said, we're going to go over discovery and evidence and stuff like that in great detail in a completely another episode, so tune in for that one for sure. Trial, that's your final hearing. That's where all of this stuff is going to come together. This is where all of that preparation, all of that long wait is all going to culminate, and you're going to end up in the courtroom in front of the judge, and the judge is going to be sitting there listening to everything that you have to say and everything the other side has to say. You're going to be interviewing witnesses, et cetera, et cetera. If you made it through all the pretrial steps and still haven't settled everything, the court will set the case for trial. This is the big day where you and the other side present your evidence, call witnesses, make your arguments, and then the judge makes a final decision. They'll issue that in writing. That's going to be your final divorce decree. Trial in a family court is typically in front of the judge, not a jury. Though, again, a small handful of states do allow for jury trials in family court, so check your local rules and regulations and laws. The atmosphere is very, very formal, and here's generally how it works, okay? You're going to start with your opening statements. Both sides are going to be able to come in and essentially state their case in a brief opening statement. You're going to tell the judge what you're in there, what you're seeking, and kind of a little bit of what you're going to be presenting and what you think that you can prove from your evidence. You are then going to present your evidence. This is going to start with the petitioner starting the case. They get to go first and everything, so they are going to start evaluating. They're going to start examining witnesses, which is interviewing witnesses. They're going to get to present all their evidence first. They're going to get to present their side of the story first, okay? You do get the ability to cross-examine and object to any of their evidence. Maybe you're objecting to their witnesses, you're objecting to witness testimony, things of that nature. Every witness can be cross-examined, so just if the petitioner has a witness, maybe they have a list of 5 or 10 witnesses and stuff like that, they're going to go through their questions, and then you're going to have the ability to ask your own questions to try to rebut anything that the witness has stated in court. Including yourself, so if you're each witness, including each party, gets that cross-examined. So if your ex goes up on the stand and they testify, and they're represented by an attorney, or maybe they're doing it pro se. If you're doing it pro se, then then their stuff is basically going to be a narrative in narrative form from themselves, and you get to ask them questions after they're done giving their their narrative to the court, which is going to be a lot more specific than their opening statement. They're going to be really nailing down all of their different issues and stuff like that. If they have an attorney, then that attorney is going to ask them a bunch of questions, and you'll have the opportunity to do the same thing. After the presentation of evidence stuff is closed and both sides have presented their case, then you're going to have closing arguments, which is basically you're just going to sum up everything that you presented. You're going to sum up all of your evidence. You're going to tell the court what you believe that you've proven with your evidence, and you're just going to basically tell the court again what you seek for an outcome in it, and you're going to point out the different weaknesses that came about through the presentation of the other party. So this is an important part, but it's a short part, kind of like that opening statement aspect. In the end, you're going to come down to the judge's decision. Usually, it's going to be taken under advisement, generally speaking, and what that means is that the judge is going to take all of the evidence. They're going to listen to both parties, and then they're going to have a certain amount of time to issue their decision. Their decision is going to come out in writing. They're not going to issue the decision right there in the courtroom. Sometimes they will issue a decision right there from the bench, telling you their decision on custody, child support, and stuff like that, spousal support, et cetera, but if the case is complex or the trial went on for multiple days, they're generally going to go and take that under advisement and issue a written decision, okay? As a pro se litigant, preparing for trial is perhaps the most challenging part. You have to organize your evidence, you have to prepare your witnesses, and you need to know the court's rules about what evidence is admissible. It's crucial to have copies of all the documents for the court and the other side, and to practice how you're going to present them and what you're going to say. If possible, go into your family court hearings. They're usually public, and you can usually sit in on them. Go to a few of them and watch and see how all of this stuff unravels and how it all plays out in the actual courtroom. Trials can be nerve-wracking. Your life as a parent is basically under a microscope for a judge to make their decision on everything. But remember, by reaching the stage, you've already navigated a lot. You've stayed focused. Stick to your outline and try to keep your emotions in check. It's going to be hard to keep your emotions in check, but that is crucial to your case, is keeping those emotions in check. Speak clearly, answer questions truthfully, and refer to your notes if you need to. If you need to ask the judge, I need to just review my notes real fast. If they ask you a question or if the other side asks you a question, that's okay. The judge will generally give you the opportunity to do that. One more thing. In some cases, instead of a full trial, courts might have a settlement conference or a pretrial conference with a judge or another mediator who will give one last push to help settle or at least streamline the issues. Sometimes a judge who is not a trial judge will host a settlement conference to give the outside perspective. If this went to trial, here's how I might rule on this, okay? This can happen a few weeks before the trial. Be prepared for that as well. It's another opportunity to settle on your own terms, okay? Again, the court is going to try to get you to settle on your own terms. They think that your agreement is much better than the court's orders. So they want to try to prevent you from having to come back, and trust me, you want to try to stop yourself from having to come back. I've been dealing with this stuff for 7 years. I have 379 different filings on the docket in my case itself. So my docket is pretty enormous when it comes to family court cases. After the trial, the judge issues the final order. That's going to throw all of your temporary orders out as soon as that final order is issued. This document is the end result. It determines legal custody, physical custody schedule, the child support amount, division of assets and debts, if it's a divorce, and any other issues that were part of the case. Read it carefully as soon as you get it. This is now the law of the land for you and the other party. Any deviation from this order can result in a contempt of court hearing. You can be held accountable for not following these court orders. Make sure you understand all parts of it when the exchange happened, who claims the child on taxes, how support is paid, and if something is unclear, you might be able to file a motion to clarify with the judge. That's just asking the judge to tell you what this means. So you need to be able to articulate that in a motion, asking them what specifically they mean by this. It's not uncommon to feel a swirl of emotions at this point. If you won, which I never consider a family court ruling in your favor as a win. Your children are still going to suffer. Your children are still going to have to deal with the aftermath of this divorce. So neither parent is going to win in this stuff. On some items and loss on other items, it's normal to get those emotional things. Okay, for people who get everything they ask for. Or I'm sorry, few people get everything that they ask for. So be prepared to win some and lose some, for lack of a better term. The question then arises: what if I'm not happy with the outcome? If you're not happy with the order that happened, then you can appeal a final order, or later request a modification if the circumstances change. We'll get to that in another session as well, but an appeal is another big, huge process. We'll talk about appeals in another session as well, but you need to really consider, is an appeal something that I can do? An appeal is only going to address clear errors of a judge in their decision. If their decision is well within their scope and well within their authority, then it's not going to be worth appealing it, because the appeal is not going to remand that back down to trial. It's going to uphold your court order, and you're still going to have to live by that court order. So it may be best to just wait for circumstances to change. If you were ruled against, you may have to do some things to get those circumstances to change. When they do, and when you have met those goals, then you're going to file a modification, which again is a completely different session from what we're here. As I said, appeals are very complicated, and they have strict deadlines, often 30 days from the time the judgment was issued, and you're probably going to need a lawyer's help for something like that. So you're going to want to consider the financial implications of that as well. Let's see. Modifications like child custody or support down the road require a showing of substantial change in circumstances from the time of the original order. So there's some things that you need to get to as well there. I'm not sure what happened here with TikTok, but I'm not going to worry about that. We're going to stay live here with you YouTube folks. So on the flip side, if the other side isn't following the order, maybe they're not allowing your visitation, not paying child support or whatnot, you may need to go back to court to enforce that. Perhaps through a contempt motion. I usually go with a motion to enforce before I file for a motion for contempt. But a motion to enforce is just saying, hey, the other party isn't following this stuff. They're not following the agreement. They're not following the court order, and I'm seeking the judge to issue a motion, an enforcement order. An enforcement order will come out. The judge will tell them specifically what they need to do and stuff like that. So the case might not be over just because you get to a final decree and you get a final divorce decree and a final order. You may still have to come back to court. Like I said, I have 379 filings in my case alone on my docket. That is an extremely large docket. It's not the biggest that I've ever seen, but it is quite large. So you might have to go back to court. It might not be the end all be all. But let's say the end of the process. Let's end the process on a hopeful note. If you've gotten your final order, congratulations. You've navigated family court successfully, and you've gotten to the end of it. Essentially, take a moment to appreciate that. Whether or not you got everything you wanted, you stood up for yourself. You made it through a very challenging experience. Many fathers and self-represented folks feel a mix of relief and a sadness at this point. That's normal. If you feel like you need professional help, absolutely go out and do it. It's crucial. So, all right. That pretty much wraps up everything here tonight. That goes through everything and is Family Court 101. I hope that it provided you a good overview, that 30,000 foot view of everything we go through. This has been an hour and 15 minutes. We've covered who's who in family court, so you know who the players are, what their responsibilities are. We've walked through how the system flows step by step from filing to final orders, and we tackled some of the big questions in this stuff and survival tips. Family court can feel like a maze with high stakes, especially for fathers who might feel the odds are against them, but knowledge and preparation are your best tools, and now you have both of them from this session to to be able to help navigate. Remember, you are your own best advocate. With the right information and mindset, you can stand up in the courtroom and fight for your rights and your children's best interest effectively. I want to thank you all who tuned in and participated. Your questions, I hope that they come a little bit more in future sessions, but I am glad and thankful for everybody that did jump in here and listened to the different things that we talked about. Feel free to continue the conversation in the comments. This will be up on our YouTube channel, Single Dad 352. They're on YouTube. It'll be all uploaded, and again, I appreciate every single one of you guys out there. This is a brutal, brutal process. As a father, it can feel like the court is up against you and you are up against a mountain. But again, if you take time to set your emotions aside, be prepared to lose some battles, be prepared to win some battles, you can get through this as well. I thank you all. Take care. And if you need anything, please don't hesitate to reach out to me directly. I'm happy to help coach you through all of this stuff. But remember, I am only a freelance paralegal. I'm only giving you this stuff as educational purposes only. I have navigated this system extensively myself over the last 7 years, and I spent 20 years as a freelance paralegal doing lots of representation for myself in different legal matters. So I present this information to you simply as a way to educate yourself and just for another resource for you guys to be able to go out and find some things that are solid advice. If you feel like you aren't handling this stuff well and that you're not doing well in the system, or that you're really up against some really heavy brick walls, I do encourage everybody to go out and seek some legal advice from an attorney. I hope you all have a wonderful Thursday evening. We'll be back again on Sunday at 8 p.m. to cover some more pro se survival topics. I hope to see you all there. Have a wonderful evening, everybody.